Ibu yes, Ibu yes, Ibu yes. 1 2 1 2 1 2 1 2. Ibu yes, Ibu yes, Ibu yes. 1 2. Long time, student. Okay, eh, how many years ngak bun?
How many years?
3 years ngak bun.
Serious?
3 to 4 years. Ah, no, 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 no. You've been working from home for a long time already.
Must not physically learn. Thank you.
Levels are high. Nomti, you kindly just go and drop the levels slightly. They're up now. Slightly.
SABC, can I get SABC?
We are.
What's going on now? Oh, we see my Can I get right? Can I? Huh? What? Oh, so the volume is fine. Yeah? Yes.
One, two, one, two.
Good morning, honorable members. Check one, two. Check. Yes, call up.
Because your PC is on. Don't have your speaker. Okay.
Check one, two. Check one, two.
Yeah, it's okay now.
Okay. We're sorting out the technology. Yeah, so we're having a hybrid meeting. Not a special for item 5, where there will be somebody who will want to raise issues with FSCA when we come to item 5. The meeting is officially open. And welcome all members of the committee, the support teams of Parliament present here, National Treasury, FSCA, Pension Fund Adjudicator. I'm not sure if SARS is here. Is SARS here?
No, it's National Treasury Office of the
Pension Fund
Fund and
FSCA.
FSCA.
Okay, you are all welcome, and media, you are also welcome. Apologies.
We have
We have
apologies
apologies for Miss Makubela, Miss Mautwe, Mr. Bateman, and Mr. Mwali. Mwali is a new member for, Mr. Mwali is a new member for MP.
Okay. Those are apologies. Let's move to item 3. We are going to get a briefing from the Pension Fund Adjudicator and the Financial Sector Conduct Authority on the implementation of the two-pot system and failure of employers to pay pension contributions. You remember, this is an issue we discussed, but not in detail, when we're at induction. With so many complaints that we are receiving as Parliament regarding employers who are not paying pension contributions, we felt that it will be proper that we invite the state entities that are responsible for this function. Because at some stage, a member even felt that we should have a special committee, but we don't have the competent or requisite skills to investigate and deal with employers who are problematic. So what is disturbing is that the number keeps on growing. I was reading the business day last night on my way from Tambo here. It was on the front page, the story of employers who are defaulting. The number is very big. So you ask yourself as to how many employees are affected if now the number of employers is getting into thousands. So you imagine yourself, you are working here in Parliament for 15 years. When you live in 2029, I have to go home, Malamlel. And the next thing, I go to, what is our Pension Fund Administrator? So Alexander, I go to Alexander Forbes. He said, no, Honorable Masonga is 00 here. We don't know. Go and find out from the speaker what happened. I mean, I will be old at that time. I'll be in my 60s, late 60s. There isn't much that you can do when you are old. There's no future. You have reached your future. So this is a very painful matter. So if it's not you or your relative who's affected, you will not understand what it means. And I believe at some stage, more especially with municipalities, we might have to summon them or go to them. We can't just leave this matter lying low like that as if we just want to get information for compliance. We will have to take actions. This is a serious crime that is committed against humanity. Surely it's very unacceptable. So let me invite the Pension Fund Adjudicator and then the FSCA. So Pension Fund Adjudicator, you can start. Over to you.
Thank you, Chair. Honorable members, colleagues. I'm going to take the committee through the 2 agenda items, the implementation of two-pot, which is quite quick, and then the rest of the time I'll spend on the failure of employers to pay contributions. It's not moving on my laptop. So now I must read from there. In preparation, in our office, what we did was we shared information across all platforms, and then we also had we appointed 2 contract staff members just to handle inquiries. Thus far, where two-pot is concerned, for September and October, we had 1,144 inquiries, and I call them inquiries because we have not reached a point where we have complaints proper as yet because of our process. So our process will first refer the matter to the fund and then wait for a response and all of that. So we are just at the point where we are handling inquiries. And if you look at that, it shows you that most people are concerned about their payment status, withdrawal procedure. So it's mostly things that were happening at the beginning. And that is really as much as we can say about two-pot as far as our office is concerned, until such time that we get proper complaints. I think the main issue that was also triggered for most people during the implementation of two-pot was the scale of the non-payment of contributions by employers. As you know, the Pension Funds Act provides for this in terms of Section 13A. I will not take you word for word through the section, but it mostly just says that employers are supposed to pay their contributions within 7 days of the month that the contributions are for, and then those contributions must then be accompanied by schedules, and then the fund must then allocate those monies to the relevant members as indicated on the schedule. I think thus far, the legislation and the regulation provides for sufficient protection. It's the implementation and the monitoring and the compliance there too that is a problem. But if you ask me as I sit here today, whether we've got sufficient guards under the legislation, we have. It's just that no one is triggering any of those protections. I have already gone through how funds must treat contributions, but what I want to highlight on this slide is the fact that when contributions are outstanding, what it means for most fund members is that funeral benefit premiums go unpaid, disability and death benefit premiums goes unpaid, and also administration expenses get deducted from that. So what you then end up having is that if an employer defaults, even if they pay 6 months down the line, but a claim arises for a disability benefit or for a funeral benefit in the intervening time that no contributions were paid, the insurer will not honor that because contributions have to be up to date at the point of claim. I think that is one risk that most members that are in this type of situation now then find themselves confronted with. As I indicated, I think that the legislation is more than enough because it provides for a responsible person for the collection of those contributions. The principal officer or someone in the fund must monitor and that those contributions have been paid, and that person must be a specific person. And also the Act places the responsibility on the board of the fund to recover those contributions. And it does that because a fund is a juristic person. And through the courts over time, they have determined that the member is not really the creditor. The person who is owed money is actually the fund. The member is just the person that it gets allocated to. But if you see the risk that now we have placed on members, we have almost turned that around, and the member is the one that must now chase, even though the person who's owed money is the fund in terms of its rules. So I'll go through the kind of funds that we have, because the implication and the data that you see is actually dependent on this sort of setup. We have got industry sector funds. Those are your funds that were previously bargaining council funds. And so they'd be either for a specific employer group of companies or for a specific sector. Then we have self-administered funds. Those are your big funds. Some employers in the mines still keep their own funds that they administer themselves, and you've got some SOEs that also do that, and they've got their own in-house administrator. Then you've got umbrella funds. Umbrella funds are initially, they were the ones that drove consolidation. They are the ones that are owned by the life assurers. So Old Mutual has one, Liberty has one, Alexander Forbes have one. And what happens is that employers, small employers, in the hope of driving costs down, they plug into those arrangements. And also some independent administrators have also started their own umbrella funds. So I've also already talked about this. I want to focus on this slide because it will explain the next lot in terms of what happens with umbrella funds, which is not data that you sort of see upfront. The
Recording in
life
progress.
assurer sponsors the fund, and then the board is supposed to have some level of independent trustee and then a principal officer. But what you often find is that, yes, there's a board, but the independent trustee somehow used to work for the life assurer. So this the principal officer might have been an employee that retired from the life insurer. So the sort of independence that's supposed to be there with umbrella funds is all lost. It's no longer there. And when they started off, the idea was that at the employer, there would be a small management committee that would sort of be like a mini board looking after member issues, and that is all but gone. It's no longer there. So the link that the small committee was supposed to provide between the fund and the members, when a board that had equal representation of members and the employer was taken away, is no longer there. And that also affects how umbrella funds chase or do not chase contributions that are outstanding at all. So what do they do in umbrella funds when there are outstanding contributions? They will issue an automated 30, 60, 90-day letter, and then they will just terminate the employer's participation. So they won't chase, they won't go to the police, they won't do all of those. So when you look at the data that the FSCA will present you, part of the data that we must look at is the data of liquidation. Because what will happen is that they will partially liquidate the employer out of the umbrella fund because they have not paid and they don't want to go through going to the police and all of that, because that is a lot of work, maybe. Then what happens is that the member in the workplace is none the wiser that my employer is being terminated out of the fund. The employer continues to deduct the contributions until maybe one member claims, only to find that the insurer will say, no, I'm liquidating. I'm in the process of liquidating the employer's participation. But a year, 2, 3 might have passed and the employer is not even in a new fund, but they are deducting the contributions anyway, but the umbrella fund has a termination date and they've walked away from all that. Then you've got your former bargaining council funds. Some bargaining council funds have got the power to recover contributions, and in our experience, they are really trying. Like your motor industry funds, you'll see that they hardly appear on the list because they've got an internal process that they will follow, and then at the end, the order will become an order of the labor court, and they are able to enforce it. They'll go through all the steps, arbitration, and all of that. But there are some bargaining councils that then do not entertain that. If our office gets a matter that involves a fund that also has a bargaining council that has got those powers, then we will only investigate the part of the claim that the bargaining council had not yet started with. Otherwise, we will leave it to the bargaining council because their recovery processes are quite robust. That is the bargaining council just in detail. I want to focus on this fund because it's one of the funds that it's quite problematic in terms of maybe what goes out there in the media about just what is happening with outstanding contributions from employers. And this is the private security sector provident fund. It's a sector fund that was established in November 2002, and it has gone through 3 administrators since its inception. NBC, ABSA Consultants and Actuaries, and now it is with Salt Employee Benefits. Now, the nature of complaints that the members will lodge there really is from failure to register. The employers don't register for participation to start off with, even though they are forced by the sectoral determination to register. The employer might register the people later, might register its participation later than trading date, meaning that there is a period where it might have been deducting from employees and not even registered with the fund. The failure to register employees as members. Sometimes the employees are registered late, and also the failure to pay contributions or even pay at a prescribed rate. And if you look at the last one where I talk about paying at the prescribed rate, when COVID hit, the fund had an allowance through the legislation from the FSCA to lower its contributions. Even though the fund lowered the contributions in terms of the rules, the employers continued deducting at the higher rate from the employees. Not only did they continue deducting at the higher rate, they didn't even pay over those deductions along with their own. Now it's back creeping up, and the situation is such that it remains more or less where the employers are doing almost as they want, and the fund doesn't have the capacity at all, from where I sit, to resolve the issue of administering the fund. And I say this because when we look at the complaints that are in our office, we have to question the capacity of the administrator to handle the fund. And that is because of the myriad of, if you look at the problems that are in the fund, it is basic admin issues, but the fund can't get around to that. Failure to keep proper member records, failure to pay benefits when they are claimed, failure to provide something as simple as a benefit statement to a member. And I quote there at the bottom the fact that the FSCA did an investigation, and then after they had placed the fund under statutory management, they had done an investigation, and then now it's got a new board. But we have interacted with that new board, and through the complaints that we see, the situation is exactly the same as the previous people that walked off. So there's no improvement to the member experience at all in terms of all the issues that are in the fund. And those 3 cases that are at the bottom that I mentioned are actually cases that came about because when the FSCA finalized its investigation, they terminated certain board members off, and those and fined some of them, and some of them then took the matter to the tribunal, and the tribunal said the FSCA should actually have levied more fines on you because of all the things that went on in the fund. And what they also say in there is really the capacity of the administrator. So as long as this administrator is on board, nothing is going to change because they absolutely have no capacity to manage a fund on this on this scale. And it's actually not me, it's the report, and it's also the tribunal that finds that they are just, and our experience with all the complaints that come. At present, one of their biggest problems is that they sit with unallocated contributions. And I'm not talking 5 million, I'm not talking 100 million, I'm talking hundreds of millions that sit in a bank account unallocated to members. The employers pay, but the fund has no capacity to say this belongs to X, and therefore what happens? They don't pay over to them. They don't pay over premiums and all of that, and claims arise in between, and members are left in the ledge. So that is a big problem. And from the board of management that are tasked with monitoring this, you get the sense that there is a failure to monitor compliance and also to recover the outstanding contributions. You'll see when we get to the end, when I indicate how many complaints were lodged by the fund itself against employers, that if you look at the scale of the non-employment, of the non-compliance, and what they have lodged as complaints. And what has been happening lately is that the fund has been lodging complaints against employers that are actually sitting in credit with the fund. And then we have to go back to them and say, but why are you lodging a complaint? Because this employer, you actually have more money of theirs that you have not allocated, and yet you are saying that they owe you something. So the record keeping there it was actually the first time that we saw this kind of thing this year, which made us start thinking that something else is going on. So our top 10 funds, if you look at that in terms of the complaints that our office handles, private security sector, provident fund, and that. And what I wanted to highlight in terms of our top 10 funds is that if you look at Fund 4, Fund 5, and Fund 9 and 10, those are your umbrella funds. But if you go and look at the list from the FSCA, those funds are not high up in terms of employers. Why? Because they have liquidated the participation of the employer. So from the FSCA side, it won't appear as if the employers were not complying, because it's a different process altogether. But for us, because the complainants come, then we discover that it's an issue of actual non-compliance. That's why I was saying that the umbrella funds are also part of the problem. And there you can see that they actually feature as 4 out of the top 10 funds. And then this is just for information again, to say what are the top 10 PSSPF employers that are not paying contributions, and that is them. And then I give you some statistics about complaints that we have received from financial year 2019-20 up to now in September. To say, you can see that the bulk of what we have to handle after we have validated complaints really does have to do with that non-compliance. And PSSPF, like I said, forms the bulk of those complaints that we receive. Now, there are funds where at least they try and come and lodge complaints against the employers. And I must say that if you look at the fact that the Transport Sector Retirement Fund ranks high up there, it's actually because over long before, maybe 5-6 years ago, they used to have many complaints, but I think they put a concerted effort somehow to recover. So most of that for them is mostly historical data, because I covered the period from 2019. The ones that start from the second fund are really our recent ones, where funds are trying very hard or are trying a bit to recover what they can from participating employers that do not comply. that is just also an extension of that list. And then there is the where we have granted relief in terms of municipal funds. And I think the situation in municipalities has just been bubbling for some time, where it started off maybe with municipalities in the Free State, Northwest, now KZN. So it was almost like you could follow it around in region. As something went wrong in a municipality, then the fund becomes a problem, and all of that. Again, that is where funds have lodged against municipalities. And this is just the first bit. I bring this slide on because these are still in the beginning in terms of two-pot withdrawal complaints. That is because we had an incident last week where it was said that people at Imfuleni municipality, it was it was a two-pot issue. It actually was not. We did search through our complaints management system and find that yes, the employees have lodged complaints against the fund, but it was not really two-pot. They wanted information, benefit statements, and all of that. Again, those are the municipalities that are complained against. As you can see, you can almost follow that region-wise to say where the issues are in terms of municipalities. And we've got total of 40 municipalities, and we have issued 125 judgments against them. And I think at the end, I just make those two recommendations. And I make this recommendation of dedicated capacity to monitor compliance, or at least start from somewhere. At this rate, I think we've got work that we are doing. The FSCA is doing something. And unless someone really sits on this problem, it's not going to go away. And the reason I say that is because these contributions actually prescribe. So the FSCA is going to give you a list, and then the list will say, someone owes contributions for 5 years, 6 years. But as we all know with prescription, it's 3 years. So most of that money can't be legally recovered. So I am not sure whether if we put a concerted effort, how then do we go and convince employers that have not complied outside of the prescription period that they must still pay if they were not paying in between. Most of our claims as it is, when complainants come, we can only give them partial recovery if the claim has not prescribed. Unfortunately, most of the data that you have out there, the claims out of that 5 billion or so, maybe half of it can't be legally recovered anymore because it has prescribed. That is why maybe to try and assist for the part of the claims where it's still within time, maybe some dedicated effort has to be put in place, and then we try and follow through on action. Because yes, coffee is somewhere in the background and it's supposed to come and help, but bringing such employers that are already used to not complying within regulation doesn't mean that they're going to comply, because currently we've got sufficient in terms of the law, in terms of the protection, in terms of the conduct standards to say comply, or else we should follow through with those actions. But that's what we are not all doing, and that's what we need to do. Thank you very much, Chairperson.
Thanks, Pension Fund Adjudicator, for the presentation. Well, let's invite FSCA.
It's on the other side.
Thank you, Chair, and thank you, PFA. I think your presentation really sets the scene for what we're going to be talking to. My name is Astrid Luden, and I'm very ably supported by a large team, as you can see this morning. I just briefly want to introduce them. I've got on my left, Serena Kamrudian, who's the head of trustee conduct at the FSCA, and next to her is Kolja Buitendach, who's the head of conduct supervision. At the back is a young lady that's part of the dedicated team for the arrear contribution. So we do have a dedicated team in the FSCA, that's Kia Tswene. And then my other colleague who's here for a later presentation has just left the room, but she'll introduce herself later. So we've got two big topics for discussion today. We're going to focus initially on the two-component system implementation, and Chair will be guided by you whether we should stop after that and just engage on it, or whether you want us to continue right away to arrear contributions. So let me begin with just providing a bit of context for the implementation of the two-component system. So as you may be aware, the two-component system applies both to funds that are under the supervision of the FSCA, but also to funds that we currently do not supervise. And if you look at the total assets value of a retirement fund assets in the country, it's about 5.5 trillion. 60% of that is currently under supervision by the FSCA. And of course, a large component of what we currently do not supervise is, for example, the GEPF, the Government Employees Pension Fund. So under our supervision, we have 872 active funds, as well as funds that we consider terminating. Those are funds that are either transferring, that either were standalone funds and are transferring their assets to an umbrella fund, and then they get cancelled. Funds that have already done that are in the process of cancellation, funds that are under liquidation. And then we've probably got about 1,000 funds that when we reviewed our register, we found there's nothing happening in them. There may be some funds in them, but we've putting together a team to help them either move into the active category again, or otherwise to help them terminate. The number of employers, total employers, is about 155,000. So that gives you an indication of the scale of employers that we're dealing with. And we have in the total funds under supervision by the FSCA, we've got 15.4 million members. Under the active funds, it's 9.6 million. And then you can see on the funds that we do not supervise, we're talking about 1.3 million active members. So again, sizable, but you can see that there are, in fact, a lot more assets on that side. So we're talking about smaller individual contributions under the funds that we currently administer. So I mentioned that the two-component system applied to both sets of funds, but of course, to all active funds under our supervision, excluding some of them, which are legacy retirement annuities, beneficiary funds, unclaimed funds, and certain occupational funds where there are no ongoing contributions. Of those funds, 856 were required to submit applications for rule amendments, and those amendments were to allow them to split the kind of contributions in line with the two-component system. 98% of those rules have been registered, and actually we had quite good compliance. By the 1st of September, we had been able to register 94% of the rules. So, and that was because we received them in time, but also because when they were queries, the funds responded smoothly. So I think overall, given the scale of this change to pensions, to the retirement system, fund system, the implementation has actually gone very smoothly. You know, we know that we had a lot of queries in the first 2 weeks when some of the systems were problematic, but actually, given the scale of the change, we think it's been very smooth. And that's because all the parties worked together. You know, the Treasury was very responsive to changes that needed to be made. Administrators spent a lot of effort, and as you will see later, a lot of funds as well on making these changes possible. Labour was a very active participant in this. And of course, SARS also really came to the party. We continue to monitor this through weekly updates, but as you'll see a little bit later, our statistics are not as current as those of SARS because we wait for the funds to actually review the information before they submit it to us. So if you may have seen this in the media recently, just an update on where we are with the withdrawals. So SARS has issued 1.9 million tax directives, and the value of those tax directives is 35 billion. Of course, all of it hasn't necessarily been paid out yet. And the SARS statistics include, for example, the GPF. So you'll always see a difference between our statistics and SARS's statistics because we only look at 60% of the value of assets. On our side, as you'll see, the data is a bit older. We have a 2-week lag, but we get weekly updates. And one of the things that we are particularly interested in is understanding where the problems are. So are there any problems, for example, with tax-related claims? Why do those problems arise? Do we need to liaise with SARS on anything? We also monitor the complaints that are received as well as the turnaround time on the processing of claims. So we've seen, since the 1st of September, we've probably seen, and I don't have the cumulative numbers, but it's certainly in excess of 30,000 complaints. Those complaints don't come to us, they go to the administrators, and we monitor how quickly they resolve those. So actually their resolution time's been pretty quick. At any point in time, these stats are a bit higher because that's for that particular week, but at any point in time, usually there are about 10% of the complaints that are unresolved. Also, most of the claims for savings withdrawals were received in September, but they keep coming in. And so the estimate, based on the numbers we've seen from the administrators, 60% of the claims came in September. So people were really waiting for this and submitted their claims. That's also why we had some of the system problems in September. But the claims keep coming in. We've still had claims in November, and we expect that there will be claims in December and January, and then probably again from the 1st of March when there's a new tax year and people can submit a claim. While the numbers vary between administrators, a sort of a global figure is that about 40% of members who are eligible to claim, so who can claim a withdrawal, savings withdrawal, 40% of those members have submitted. So I think that gives us a good indication of how careful people are about their retirement savings and whether, and we'll talk a little bit later about why we think people do come forward. Just from one administrator, we received an average claim value, which we thought we would share, which is just over 13,000 Rand, which gives you a sense of how big the claim is that people are submitting. It is it's certainly below the 30,000 maximum. So this brings me then to just talking very briefly about the profile of people who are submitting. So 93% of the claimants are earning less than 550,000 Rand per year. So we're talking about lower and middle income consumers or members. The largest portion of those claimants have a fund credit between 100,000 and 250,000. And so that means that is what they currently have in their fund. And then the 76% of the claimants on in that group between 30 and 50 years old. There's a slight bias. It's roughly 50-50, but between those two, between the 30 to 40 category and the 40 to 50. Interestingly, there are people that have claimed between the age of 60 and 65, which, you know, I would have expected that people would think that maybe they should wait for that rather than affect their retirement savings at that stage. But we still see some claims. And then most of the claimants work either in the retail or the wholesale trade, interestingly in mining. So 40% of those eligible in mining have claimed, manufacturing, and we've also seen it in the financial services sector. It does vary a little bit by administrator, but I think the retail trade has been remarkable across all of the administrators of whom we've received data. So the PFA has talked to some of the complaints, and I think in a bit more detail. We do monitor the complaints that right from the beginning. We looked at the kind of complaints that have come in, and we've seen the changes, but the ones that I'm highlighting here are the ones that we're still seeing coming through. They relate to delays in payment. And it seems that initially in September, when there were some system issues and where people weren't necessarily capturing everything correctly, quite a few of those claims are still being resolved. Then when people come and they put in their claims, they find that the amount that's in the savings pot is not quite what they expected. And then also whether or not they are eligible to claim, so how much they've actually got. So in part of that could be related to arrear contributions, but it could also just be that people have had greater expectations about what's in the actual retirement savings component. And then people have also been surprised by the amount of tax and other deductions. We've certainly seen that. And then lastly, we've seen complaints about employers failing to pay. We also received this matter was highlighted to us by Labour through our NADLAC interactions, concerns around the fees that are being charged for the two-component system withdrawal. And so in response to those complaints, we issued a request for information to administrators and funds, self-administered funds, to understand both the costs of implementing the two-component system, but also how they are recouping those costs. And I wanted to just share some initial analysis. It is quite a complex, the data is quite complex. We're working through it. We're still looking at some of the comparability of some of the information we received. So we will publish a report, but we want to make sure that we've fully assessed the data. So this did take me by a bit of surprise myself when I saw this number. So the cost based on the feedback we've received from the administrators of implementing the two-component system has been 1.6 billion. Most of that has come from system changes, and all the large administrators had significant spend on their system changes. But you can also see additional costs, for example, around the member communication. There was a lot of communication and education that needed to go out. Their staff needed to be trained. They also needed to appoint additional staff to deal with queries in particular. Some of them established call centers. And the industry expects that the cost, so this is not just a once-off cost, right? There is an expectation and a projection that annually, probably the cost will be increasing by about 300 million. As I said, we're still working through that. We also asked the administrators to tell us over what time period they were going to recover this cost. not just the initial costs, but also the ongoing costs. And from the information that we received, it looks like it will be a period of 6 to 7 years. So we'll be working through that to understand exactly, what the implications are. We've received projections for the next 3 years, and it looks like with the initial cost, as well as the ongoing projected annual cost, after 4 years, they will have recovered about half the expenditure. Then we asked them, how are you going to recoup these costs? Because, the costs of implementing these changes do need to be recouped, but in a reasonable way, of course. And so that is, I think, what we need to test as a regulator. So about 64% of the funds and administrators responded said that some of those costs, either all of the costs or some of them, are going to be absorbed either by the administrator or by the fund. So, for example, and let me highlight one that I think is not going to be controversial, is the South African Reserve Bank, for example, has indicated that they fully absorb the cost, nothing will be passed on to members. But then some of the funds and administrators have indicated that they will be charging a once-off fee. Some are charging a once-off fee as well as a fee for every withdrawal. And in some cases, the funds have split the cost between an annual increase, so a percentage increase in the administration cost, as well as a savings withdrawal. And I think it's quite a difficult issue, because on the one hand, we know that only 40% of the pension fund members have claimed and are maybe likely to claim in future. And there are a lot of costs associated with that. So if there's no savings withdrawal fee, the other 60% are also paying for this additional cost. So we need to balance this. And I think that's what funds and administrators are trying to do. There seems to be a lot of variation in the fees charged, especially for the savings withdrawal fee, and we haven't listed them here because there's a little bit of complexity in it. Some charge only a flat fee, some charge a flat fee plus a percentage up to a maximum. So it's not a simple comparison, and one that we want to spend our time going through, which is why I said we'll do a report early in 2025. We will also be looking at the fees at an administrator level. So we're looking both at the cost and how they're recovering those. And where we see any outliers, we're going to be engaging with those funds, those administrators, and that we've already indicated to them. I know I've been asked in the media whether or not we need powers to regulate funds like this. At this stage, it would be premature for us to express any view on that. But I think ultimately what we want to make sure is that members get value for money. So we do want to look at the administrative cost in total, not only the administrative cost that is imposed as a result of these legislative changes, which of course have brought a lot of benefits. We also think what's really, really important is that there's transparency around these fees, both so that funds, who are the ones negotiating with administrators and are the ones making decisions about fees, so that they have comparable information about, and that they can shop around as well for administrators, but also members need to know what these fees are and what the spectrum is out there so that they can hold their funds to account. So, Chair, I don't know if you want us to proceed to the area contributions. Yes. Okay. So let me then pivot a little bit and come to talk to something which, is an issue that for us over the past 2 years has been a very big issue, and that we have, through the publication of these lists, really brought to the fore in the public domain. And that is really what we wanted to do with this naming and shaming. We wanted to make everybody aware of what the impact is, and members aware of what is happening with their contributions, and also to highlight to funds what their responsibilities are. So employer contributions are not a new, arrear contributions are not a new issue. We've been observing this as a regulator since the mid-2000s, but it's really become an unavoidable and pressing, much more pressing issue since the COVID pandemic. And I think the PFA talked to that when she gave the example of the PSSPF. We don't see, as again was mentioned, a lot of arrears in commercial umbrella funds because they terminate the employers. But of course, we see it in the bargaining council funds because that's where the contributions are mandatory, and that's where it's becoming very apparent. As a regulator, because we don't have direct oversight over employers, our focus tends to be on the funds and holding them to account. So that's the locus of our activity. It's the funds who must take reasonable steps to recover the outstanding contributions. And when we engage with them, we ask them, what have you done to do that? They need to lodge a criminal case with the police. And then the matter is escalated to the National Prosecuting Authority. Because these are criminal matters, that's where how the enforcement mechanism works. And I think, as the PFA mentioned, that's the part that needs to be strengthened, we think. We've talked about the volume of arrear contributions. It's 5.2 billion. It is a huge number, but of course, there's some complexity in that number. So that number excludes, for example, umbrella funds. It includes a lot of interest payments. So we don't know what the late payment interest is that's accumulated. And of course, where it relates to, for example, arrears that may have prescribed, it will skew the picture as well. But from our perspective, unless prescription is raised as a defense, these arrears need to be considered as arrears. They are funds owing to members. And, we would not want to see a situation actually where these contributions expire because somebody took those monies from people and hasn't paid them over. So there needs to be a responsibility. It is an issue that has a huge impact on members, Chair, as you mentioned, but in terms of the health of the pension system as a whole, it is a relatively small component. It is about 0.2% of the total assets of just over 3 trillion rand. So it's not something that threatens the pension system or even individual funds at this stage, but it has a huge impact on members. We're talking about in our latest round of publications, so we require pension funds, they are required in terms of conduct standard to notify us of employers that are in arrears. And in our latest round, we've received a notification of 7,770 employers. We don't publish all those names because there could be a problem around allocations, for example. So we won't publish everybody who has, 1 month of arrears. In our latest publication, we published just over 2,000 employers, so the names of 2,000 employers, and those are ones that have been arrears for more than 5 months. We have seen quite an impact actually with this publication. So the data that we received from funds shows that since our first publication and our last, 1,000 employers have already rectified the situation, either by paying up or by concluding agreements with their funds. And we've also seen more funds reporting now. So in the latest round, we've had 51 funds that are reporting. We're talking about in excess of 300,000 members. So we are talking about a lot of people that are affected. Here, we just wanted to show you where the biggest problem areas are. So We know that the private security industry is the biggest problem. You see that both when we look at the percentage of employers that are non-compliant in terms of the total of the total. So the highest proportion is from the private security sector, and that in terms of numbers is 2,379. But I will talk to that a little bit more. So you will see from this that we're talking about the bargaining council funds. We're talking about the areas where there is primarily central bargaining, and then where it's mandatory, and then of course also municipalities. I just wanted to highlight that you will see in this slide that we have 168, I think, municipalities that have been complained, that have been reported to us. But of course, they will be reported to us by more than one fund if they are a member of more than one fund. And so when I talk to the numbers in the municipal area, you'll see that we're talking about slightly fewer. Then, you know, the picture that does worry us is municipal arrears, because, you know, we do have the same, you know, in the private security industry, we understand that we are talking about small businesses that have contracts. Their incomes may be variable. So, you know, and that needs to be, that obviously creates complexity for the fund, but, you know, there's a lot more understanding. Whereas in the municipal area, we're talking about organizations that receive revenues and can plan the expenditure of their revenues. So it's really unforgivable that they are taking contributions from members and using those to fund operational expenditure. Yes, we understand that that is to provide services to communities, but it's not right that the workers are cross-subsidizing those services. We can see the areas of the biggest problem, and the PFA talked to that. I just wanted to highlight here we have 149 municipalities that have arrears. So that's 58% of all the municipalities in the country. It's across 10 retirement funds, and 69% of the arrears sit in the Free State. Of course, you know, should the municipality raise the issue of prescription, we hope they don't. But, you know, some of those arrears are quite old, of course, in this area. And this is, you know, if municipalities cannot afford to offer a pension benefit to their members, then that's what they should be engaging with them from a bargaining perspective. What's also not acceptable is that these arrears accumulate and continue. And so, you know, if you're in a situation where in the Free State, 23 out of the 22 municipalities are not have arrear contributions, we're talking about something that's becoming systemic, certainly in that province. So the Private Security Provident Fund, I think the PFA has given a very good overview, and so I just want to highlight a few things here. We entirely agree that there's a problem on the administration side. You can see that we have 340 million of unallocated amounts, and then we've got arrear contributions of 305 million. So one does need to ask questions around the relationship between the unallocated amounts and the arrears. And our team can talk about this a bit more. We have also given the new board some time to settle in. But this is, we think, the single biggest problem, you know, in the area of arrear contributions. We know for the PFA, it's the source of the largest volume of complaints. So this is a priority fund for us. And then maybe just in conclusion, let me just say what we have done and what we will continue to do. So we will continue publishing names. We will continue looking at receiving the data, publishing the names, because we think it will continue to have an impact, especially if it does affect, for example, the abilities of employers to contract, which is why we think, a lot of employers have paid up. So we think this is important. We will also continue monitoring the complaints as we do that the PFA receives. I just wanted to mention that even though, for example, the Alexander Forbes umbrella funds are not part of the list that we receive, as a result of your complaints, we have put them on our watch list. So they are in the purview of our supervisory activity. We are also reaching out and engaging with employers, even though, we don't have authority, legal authority over them. That is something that we will have, hopefully, when the COFI bill is passed, reviewed and passed by this committee. But so we are actually engaging directly with the employers, with the bargaining councils, because, there are things that they can do themselves and responsibilities that they have themselves. We also think that we need to support where we can, and there need to be engagements between the employers as well as the funds. For example, to conclude agreements on how things are going to be, things are arrears are going to be paid. And also engagements, for example, in municipalities where there are a lot of arrears and there's no funds are being paid over, or not sufficient funds are being paid over. In those cases, we think it's better that municipalities stop making deductions from employees so that employees can make their own decisions about how they want to save, rather than putting money into something that is then not being paid over. But those are negotiations that need to happen, of course, also by the employer with the employees, but also with the fund. We are focusing on the most problematic funds, and will be concluding and in the process of engaging what we call enforceable undertakings. That's where there's a commitment made by the fund for certain steps. Sometimes we can have an enforceable undertaking that is 3 ways, that involves the funds, the employer, and ourselves, and that allows us then to monitor it quite closely. And then, of course, the supervisory engagements, particularly also with administrators. And I think the PSS-PF is, of course, a prime case for that. We also think that the whole enforcement ecosystem needs to be strengthened. And that means we engage with the police. We've had engagements with the NPA, and we need to engage with as 3 parties together. The NPA has got a strong team that is taking some cases through. So we've seen some case law, but we do need to make sure that at the police the capacity exists, and that these matters are taken seriously enough. We also think that SARS can play a role, because employers that are not paying over should also be in trouble with the tax man. And then lastly, we're also engaging with the AG, the Auditor General. They have particular powers as well to hold municipalities, as in the employers, liable. They can hold them personally liable as well. I think the challenge there is, in the municipal area, and I think we need to be, we need to have some understanding, who would want to be a municipal manager of a municipality that has huge arrears where you can be held personally liable. So I think, we need to also understand that we're talking about a capacity issue there, and that we want to make sure that we attract, the best candidates for these critical roles. And then lastly, we're also engaging at NEDLAC with the social partners. Thank you, Chair. That's it from us.
Thanks to FSCA for that presentation. And we request National Treasury to also come on board. I'll see if they've got the document here that they've sent for us. Yeah, 2 pages.
No, I don't.
It's the hot seat.
Yeah.
Yeah, it's just practicing.
Yeah, it was supposed to just work,
Let me check it out.
but I had 2 cables. You have one. Just
Oh,
try
the
the
other
other
one
one,
in,
maybe.
the other one in. I think that's the switch.
Maybe you must do that FM whatever. I remember there was something.
Okay, Chair, not sure if the members have copies of the slides. But it's quite a short. Yes. It's quite a short presentation. Yeah, I'll just speak to it. Oh, just
It hasn't gone. Are you?
yeah, I am connected.
Online? It's a good thing they put me to Treasury. It's my goodness, it was I keep panic stricken.
It's not going.
Or not subsidy. You can speak to the document, you have the copies.
Yeah.
It looks like there's a problem. Yeah, just
Okay.
talk to the document.
Okay, good morning, Shan. Good morning, members. My name is Alvina Taylor from the National Treasury. I'll quickly speak through the presentation. It's just refusing to load. It's only 3 slides. I don't have much on my side because the adjudicator and the deputy commissioner have covered most of the stuff. So in terms of the two-pot system, we are in progress. We are now finalizing the second revenue laws amendment bill, which has gone through this committee. Am I not audible? I need to come closer here. Can you hear me now? Okay, let me know if I'm not audible. So following that, the second revenue laws amendment bill, the two-pot system will be finally implemented in terms of the legislation. So this legislation covers technical issues, mainly switching off the need to have directives when members move funds within the same fund. That's what we're trying to correct. And other issues that we need to attend to as National Treasury, together with the Office of the Pension Funds Adjudicator, as well as the FSCA, is the continuous monitoring of the implementation system of the two-pot system, which this committee has requested us to do. What the Deputy Commissioner spoke to when it comes to the two-pot admin fees and area contributions, which is an issue that is being discussed today. So it's unfortunate that the implementation of the two-pot system has brought again to the fore this delayed contributions by employers towards the fund. And as National Treasury, we strive to improve customer outcomes when it comes to retirement savings by ensuring that we have improved and stronger regulatory framework. Hence, as mentioned by the Pension Funds Adjudicator, that the law is there, but there are some gaps when it comes to the employers being true to the law. So from our side, we will try again to strengthen the law by introducing through the coffee bill employers as supervised entities. So that gives the FSCA powers to make sure that they know who the employers are, they have conduct standards, they have regulatory instruments to ensure that the employers do what they're supposed to do. So whether that will work, we will wait and see. So moving on to the second slide on the non-payment of pension contributions by employers. So we started as Treasury to strengthen the law when it comes to governance by retirement funds through the Financial Services Laws General Amendment Act, which made the non-compliance with Section 13A of the Pension Funds Act a criminal offense, punishable by fine or imprisonment, and also holding the persons, the key persons that the adjudicator spoke to, personally liable for the non-compliance. So the PFA, the Pension Funds Act, places the responsibility of ensuring compliance with the board of the retirement funds. So before we even go to the adjudicator or the pension or the FSCA, the board needs to ensure that the employers are up to date with the contributions, because they need to provide certain requirements, statutory requirements to the FSCA. And the board also needs to take all reasonable steps to ensure that those contributions are collected and report non-compliance. So moving on to slide 4, is that as Treasury, at the moment, we have the legislation in place the policy in place. So together with the FSCA and the Office of the Pension Funds Adjudicator, we need to see where the gaps are. What do we need to focus on to ensure that this matter is resolved? Hence there, I'm not as such providing solutions, but I have questions on my side, which I think we need to address, and I need to be giving you solutions, but hopefully we can collaboratively come up with some form of measures that we can use to address this problem. Firstly, is the legislation sufficient? Are there gaps that we need to address from Treasury side to resolve this problem? Are the criminal sanctions enforceable or not? And over and above the criminal sanctions that are in place, do we need to put in place as Treasury or as government further measures? For example, this is a criminal liability. Do we need to have now a civil action that funds need to follow in ensuring that these employers abide with the law? And again, maybe from the FSCA, are funds doing the necessary compliance in following up with the employers before the fund can go to the adjudicator? Do funds follow up with the employers? Do they inform their members? So all those steps, are they being followed by the funds? And with members not being aware and only being aware when they have to withdraw, how do we get them actively involved? I don't want to be stuck when I'm 65 that my pension fund GPF has not been paying. So how do we get the likes of Alvina and everyone in this room actively in your fund? Do you check your statement? Are you engaged in your fund to make sure that your everything is in order, or we wait until when we exit the fund? So these are all the questions. It's not just Treasury that can do something. It's not only the Pension Funds Adjudicator that only becomes aware once there's a problem. It's not just the FSCA, it's all of us. It's a collaborative effort, maybe identifying gaps, who's doing what or who's not doing what they're supposed to do. And let's close those gaps and ensure that at the end of the day, members of funds are protected and the industry serves them better. Thank you, Chair.
Thank you, Mr. Treasurer. Let's come now to item 4. Deliberations by the committee members. Members, there we are. Then we engage. Honorable Van Buen, Honorable Honorable Beasley, Honorable Scott, were you raising hand? Okay, Baleka, Scott. Honorable Alexander, somebody is raising an issue, but we seem to be wearing the same jacket, so they say it's a GNU uniform. Dr. Thorpe said it's a GNU uniform. You don't want to be in the GNU. We want to make you a minister. We'll create another post in the minister, in the cabinet. There are many positions in government. We can make a minister of 2 port. I will take 2 port out of treasury and give it to you. Yeah, we've got serious problems here with pension funds. So we'll make Honorable Beasley a pension fund minister. Honorable Van Rooyen.
Thank you very much, Chairperson. But also let me take this opportunity to appreciate the presenters. National Treasury, you are very stingy with information. Just come fly all the way from Pretoria for 3 slides. Very interesting. Chair, to PFA, Pension Fund Adjudicator. The first question will be on their assertion that there is a problem of the administrator's capacity. I think that refers to the private security pension fund. I just want to know, because it seems as if this has been recurring. You cited 3 appointments so far of administrators. It begs the question then of the process followed to appoint this administrator. Who is in charge of this process? Secondly, could you please shed some more light? What do you mean by saying there is a need for a dedicated capacity? Does that mean the current capacity is not adequate to address this new development with its related or associated challenges? What do you mean by reference to the required dedicated capacity to deal with the situation? Thirdly, you see, in your own submissions, you admitted that the private security pension fund non-compliance issue is not a new problem. Seems to be a perennial problem. I'm not sure what has been done either to sanction them, or maybe what stops, I think it goes also to the regulator. What stops you from deregistering this fund, because it's undermining the laws of the country. I'm not even sure, as they exist now, which provision of the country statutes allows them to continue operating. Maybe you are better positioned. Maybe it's the same provision that makes it difficult for yourselves to move with speed to deal with non-compliance issues as identified by yourselves. The fourth issue, Chairperson, I hope you are not going to invoke that provision of 2 minutes, because this is a very interesting topic, and it's affecting a lot of lives, and more especially those who sent us to represent them here. So please, we just want to unpack this thing properly for the sake of those whom we are representing here. In our engagement as NK Party with private security companies, more especially black-owned private security companies, it came out very clear that they seem to be blaming government departments for not paying them CIRA-related rates. I'm not sure, because as much as we are enforcing, we need to look at the 2 sides of the same coin. What might be causing some of these, without justifying issues of non-compliance, but we need to be fair to make sure that we close all these gaps. I'm not sure if was ever this mentioned, and if it was ever mentioned to yourselves, is there any takeaway from this submission that as we try to close these gaps, we must pay attention to, because they are very clear that more especially black-owned private security companies, they are unable to obviously honor their financial obligations in the main, including these contributions, as a result of government departments who are not paying them CIRA-related rates. In fact, to be more specific, who are exploiting them, because they are paying them less than what is regulated by an authentic and legitimate regulator, which is CIRA. Of course, there are other findings, and I think some of the findings are cited in your presentations. But I haven't heard you saying anything about this one. I don't know if maybe it was only said to us, or was it ever raised with yourselves, but how authentic is this submission? It will help us as we try to play our role in providing a solution to this problem. FSCA specifically, I know it will also go to National Treasury. The issue of financial literacy levels in this country. We know we've been saying this thing as part of dealing with the transformation of the financial sector of the country. Now we are having this two-pot thing. And I know the purpose is noble. Let's deal with distressed, financially distressed households or individuals. But I've seen what you have presented now, the patterns of access to this is reminding me of this discussion. Our people financially literate to understand that this is not a once-off Christmas provision. It's meant to assist them just to deal with their current unfortunate situation due to our economy that is not performing well. What effort have we put into educating our people around this particular intervention? I mean, it goes to the regulator as well as the National Treasury, because the financial literacy levels of this country are very, very high, for obvious reasons. You know, the regulator acknowledged that they are not sure of the best model for cost recovery because it seems as if it's a learning curve to the regulator. My question is, was it not an envisaged eventuality? But also, are there no best practices that can be put in place? Because if we keep on procrastinating this intervention, it's going to create problems. Because now administrators will be flexible in terms of how to recover the cost of administering this particular development. So if we are not moving with speed to close the gap, tomorrow you'll be here. We'll be dealing with complaints of administrators. Already, in fact, I know even with Alexander Fox, those who are representing us in that board, they are saying Alexander Fox has moved. The board has moved and they have already passed the cost to us. I want us to be a bit proactive on how we deal with issues of a developmental state, because we are aware that this is going to happen. So we can't throw our hands in the air and say, God help us, we'll see at a later stage. It will be too late, because we'll be here again saying there is this other province if we were not aware. We are aware. What are we doing about this problem? Because we can't leave this thing to the mercy of administrators, because there is a lot of what we call chance takers involved in the industry. It will be interesting just to get to know of all these non-compliant, the top 10s and what, the steps that we have taken to deal with their non-compliance. Because it's massive. This thing, them not to be compliant, it's a certain status, which can be changed, which is very unfortunate. They are now categorized as the top 10, the top 15. It will be interesting. What have you done so far since your establishment to deal with issues of non-compliance in these entities? If we can just do statistical breakdown, Chairperson, and that will give us an indication of the efficacy of your existence. Because if you can't address that, then simple says you obviously, there is a need for us to look at the role of these institutions in our developmental, what you call state. So it's important that we get that breakdown as to this one started this year of not complying. These are the issues that we've been dealing with, but it seems to be recurring. Why do we have such service providers in our system? So that statistical information will help a lot. Is the National Treasury, you said we are waiting to see if we're expecting a miracle or manna from somewhere for the law in terms of strengthening the law. You can wait. That approach lacks sophistication. It's more a trial and error approach, I will argue. Maybe you can prove me otherwise. We need to move with speed. We are empowered to move with speed. This is our responsibility as National Treasury to deal with these particular laws that we think there are gaps. And we need to move with speed. We can't wait and say, we'll wait for a miracle to happen. No. We must move and intervene accordingly. But also what is interesting, Chairperson, is immersive. We are the first country to be going through this thing. I don't know, are there no best practices that we can learn from instead of waiting and seeing? Maybe if there are best practices that we can learn from, we need to opt for those. And Chairperson, I think, I fully support your earlier submission because it's clear out of all the presentations. This is a new thing to all those people that we're expecting to deliver on. These institutions are clear in their submissions that we are learning on how to manage this thing. It came out very, very clear in all their presentations. So I fully support your call, Chairperson, that those who are not compliant must also be engaged. So as we conclude this second, because there's a lot also to learn from them. We shouldn't only focus on those who are given the authority to enforce. Let's also learn from those who are not compliant. So as we get their story, exactly why are they not compliant? Appreciating, of course, the findings that you have already made in your efforts as institutions and powers to do that. But I think we need to go beyond that. Let's get them seated, give them opportunities as we are giving opportunity, so as we learn from them. And hence, as MK Party, we support the call for us because it's clear that there's still a lot of work to do, specifically in this area. Because if there's anything that has this intervention done, is to expose the weaknesses on how we regulate the financial sector of this country. So that's why we support the call that has been initiated by some members in this committee that we must have a special committee that deals with this matter. So as we deal with it as quickly as possible, because now that it's running, I mean, the next financial year is just around the corner. We'll be having another plethora of complaints submitted to us, So in a nutshell, Chair, I think so far the evidence presented by presenters here clearly, concurs with our submission or our call that we need a special committee to deal with this situation. Thank you very much.
Thank you, Mr. Problem left.
Chair, let me just qualify my input by saying that I'm not a lawyer. I know very little about the law. But from what I heard this morning, that the issue, it's not a problem, it's an issue, is that pension fund monies were not paid over by employers. So that is the issue. The consequence of that is quite clear in the law. Section 13A of the PFA says that if an employer behaves like that, it is a criminal offense. The problem is not that they did not pay over the fund. The problem is nothing was done about it. Nobody did anything about it. And my limited understanding of the law, the moment anyone becomes aware that a crime has been committed, as it has in this instance, that person has an obligation to report it to the police and to the authorities. If a person who is aware of a crime that has been committed does not report that crime to the police, that person becomes guilty or liable to be prosecuted for not reporting a crime. In fact, I'm worried, Chairperson, about you and I, and all of us in this room, because we have just been made aware of a crime that has been committed. And we actually now have an obligation to report it. Otherwise, we will also be found guilty of not having reported the crime. And we will join the FSCA and the National Treasury and all the people that were aware of this crime. Now we have just been included as people who knew about the crime. That's the first question that I would like clarification from maybe somebody with a legal background to say, what does this mean? When a crime has been committed with impunity, it has been allowed to run for so many years, people were aware of it, and nothing was done about it. There was reference, I think, in the FSCA presentation of the, I think you call it the enforcement ecosystem. The NPA and the Hawks and so on were informed. In fact, were they not supposed to have been informed of every single incident, and every single incident to be prosecuted individually every time somebody did not pay over a pension fund and we were aware of it? So I think that is where the problem lies. The second one is the issue of prescription arose several times, that we're not aware, we're not sure that we will be able to recover this money because some of it may have prescribed. Well, the thing about prescription is that a debt or a liability prescribes if nobody does anything about it. So if nobody issues summons, if nobody issues a letter of demand, if nobody does anything about it, only then, after 3 years of not doing anything, does a debt prescribe. When a debt does indeed prescribe, a civil liability may arise, which is who allowed the debt to prescribe. And that person becomes responsible for having allowed the debt to prescribe. Whoever was supposed to issue summons and didn't issue summons allowed the debt to prescribe. And therefore, the people who are prejudiced by the prescription of the debt may have a claim against those who allowed it to prescribe or who were aware that it is going to prescribe and nobody is doing anything about it. And I'm getting worried that now we are also being dragged into this thing because now we've been made aware that there is such a problem and it should not continue. And the third issue that I wanted to raise actually has been raised by my colleague here about the fees. What is the possibility of capping the fees and having one standard for the fees for the whole industry through either regulation or legislation so that we do not have this differential treatment of fees? Very soon, you will find that some people will take advantage of this lacuna in the regulation of the fees and start charging exorbitant amounts. And then we will come here and complain again that they are charging exorbitant amounts and they are acting wrongly and we don't know what to do about it. Thank you, Chair.
Thanks.
Of pension funds.
Yeah.
Cabinet.
GNU.
Just a couple of, just in terms of the two-part system, have there been any lessons learned to date which we can make the system improving going forward? And I just want to compliment everybody involved. Whilst there has been some teething issues, it's been a very smooth process. So well done to everybody involved. But are there any lessons to be learned And you said the average claim is 13,657. Is that the maximum that people could have drawn out, or have they drawn generally less than the 30,000 that was available? And then in terms of the costs, I think it's a big factor, because there's no such thing as really as a free lunch, and ultimately people are paying. And I just think it's important that an eye is kept on the cost of this two-pot system. I said 1 billion out of 35 billion. That's nearly 2.5–3%. So it can get high and can have quite a big impact. And then, Chair, I think it's such a valuable discussion to have, because behind, as you mentioned, there's real lives and real stories behind these pension fund contributions. Imagine working your whole life, you go and get your pension and there's nothing available. I mean, it's really a tragic story. Or also if you die and your family can't bury you, but you've been paying your fees across. So I really think as a committee, it's something we need to focus on. So I'll just to date, has any criminal charges been laid against anybody, and has any prosecutions been made? I mean, I was at a presentation by the NPA the other day. They're so overwhelmed. I mean, this is just going to overwhelm them more. But I'll just be interested to know, has anybody actually been criminally charged and held liable for this? And then the non-payment by municipalities, the arrears, is that a crime as it currently stands? Are those, that is quite scary. And I think, Chair, I think if we could get COGTA here sometime, the Minister of COGTA, just to come in account, because I think this is, the amount of municipalities that are in arrears is just totally unacceptable. We don't have control of the private companies, but in terms of the municipalities, we do. So I just think, I mean, it paints a very, very bleak picture. Thank you, Chair.
Thank you. While you are still there, Honorable Beasley, we are a Parliament of the Republic of South Africa. Nobody just does as he wishes. So we can call private companies here. We are a Parliament of the Republic. So we have got authority over everybody from here in Cape Town to Museum. Yeah. Thanks, Honorable Beasley.
Thank you very much, Chair, and thank you very much to the presenters, FSCA, National Treasury, and all the members who have presented this morning. My first question would be a clarity on FSCA. Sorry, I'm a slow learner. You spoke of 1.9 million not supervised, vis-a-vis 1.3 million active members. If you can again explain that 1.9 vis-a-vis the active members, if you can just re-explain. And you also spoke of unclaimed benefits. What are the reasons? Do you know why people are not claiming? What are the reasons behind that? And the other question to you as well is the impact of claiming at an early age. Are people made aware of the impact, which is the withdrawal fees? Are they aware, because people might be withdrawing that amount of money or percentage we have spoken about without knowing exactly the consequences in terms of the withdrawal fees, as well as the tax in this? How does the withdrawal then impact their tax? And I think the bone of contention, we might sound like a scratch record from my colleagues who have already spoken. The bone of contention here is non-compliance, of employers, whether it's government or private. The law has been there. There has been an existing law, Section 13A of the Pension Fund Act, amended or not amended, but the law has been there. And some companies and municipalities have not been complying. So what is it that you are going to do differently now? Which then boils back to the question by National Treasury. She actually asked the questions that I had noted to say, unfortunately, members only realize
this non-compliance at the tail end of their lifetime, which then creates a lot of problems because it does not just affect a member. You know, if you don't get your pension, it affects your family because this has been an overtime investment during your working time, your working life. And you've been investing not for yourself, but for your kids and for your family. So it affects even the health of a member. I mean, if you realize that you have been working all these years for 40 or more and you have not been, I mean, you don't have a pension, you can die. You can even die earlier. So it's a serious offense. And why did we have to leave it to this tail end? Hence my question of what is it that you are going to do differently to enforce compliance and to make sure that those who are found in contravention of the law are made liable and they pay for their actions. But also, how do we protect the life of ordinary citizens of this country whom we represent? So I think for me, that is the bone of contention. It is unfortunate that you find municipalities, the percentage 58% that you've mentioned, it's quite a lot. Even with the private sector, it's quite a lot, and there are a lot of people who are being affected by this. So I think it is high time that the law has teeth to bite, because if you have a law and people contravene the law and there are no consequences, yeah, it doesn't serve a purpose. Thank you, Chair.
Oh, thank you. Honorable Bruno, thank you. I thought I've got this big voice. Chair, I think we are dealing with quite a web of a complex system here. Because you have got the employers, you have got the fund managers and so on. Now, we suspect the employers are not paying. They might be paying. You've got board members who are not taking their responsibilities serious, but also they are finding themselves in a very, very lenient environment where they can do anything. Because if there is no action whatsoever that has been taken against board members, I can imagine, Chair. I mean, you walk in there where you are seated, you walk in this room, you'll find millions of rents that are ownerless. What are you expected to do? You buy mansions, you buy farms, you buy whatever that you want, because it's ownerless. And there's nobody who's going to force you to show the owner of the farm, of the money, and it's been there. So what happens is that the money can just disappear and nobody will actually be held accountable for any cent or rent. So we are creating a very serious challenge and a problem where board members can actually create their own, piggy banks. They can take whatever they want. They can loan themselves. So if we all seated in here and we say, you take, who will be? And if nobody is actually auditing that as to what are these monies, is it interest from members and so on, and members might have passed on, and what happens with that money finally? But secondly, Chair, is the issue of the protection. How far does it go? And when does it get triggered? I think you said that from the pension fund, that the member needed to, there must be a proper, reporting or complaint, which is worrying me. Because from the look of things is that you've got the members, you've got the funds, you've got the board members in there, and some of these people might be coming from the employers. Now, if they are all benefiting, it means the members are not necessarily being protected. And FSCA and yourselves are the only board that is actually authorized to be able to do that. Because I think not even AG comes in, but AG will come in to help us to audit the fund, will come and help us to audit in terms of the role of the boards, whether they are doing what they're supposed to be doing and what has been happening. But it will not have the authority to make sure that there is compliance. They can give us the reports and we talk about them and so on. But until such time that there is consequence management against the board members in those funds, we will not be able to adequately deal with the matter. There must be consequences for those board members who are sitting in those funds. Because honestly, if there is none and we are just told that, no, you can be told to pay, they'll just take the money. They've got hundreds and hundreds of millions. They just take and put there. That's it. And they continue, it's a routine. Every time you say 10 million, they put it there because they know that is what you'll want from them. But they could be helping themselves as well on those funds. So because they're not paying from their pockets, they'll continue to pay. So I think there should be proper real consequence management for board members who are actually involved in these funds so that they are held liable. Because this, I can imagine my grand old man comes and tell my mom that, there is no pension fund. They'll just think, oh, you are sitting in Cape Town, and the money ended up in Guguletu, Khayelitsha, or somewhere in Pelican. Because it used to happen with our, old men who went to Johannesburg and they come back home without anything. But it can be us as those that have got the authority to make sure that things don't happen. And we're still found wanting in terms of what should happen. It can be. Because the buck stops with you, both the Pension Fund Adjudicator and FSCA. The buck stops with you. I think we need to take that responsibility and make sure that whatever that happens doesn't happen in the manner that it has been happening. Well, it doesn't take Parliament to say, let us form ad hoc committees. What can ad hoc committees achieve? If you're saying this is a challenge and you even feel overwhelmed, what can this ad hoc committee do? Nothing. Just to deal with the report alone. So I'm saying we need to get a report that says systematically this is how we're going to deal with these issues. The municipalities will give us reports in terms of their contributions, why they're not contributing. Because in a municipality, there is a MFMA. There is nowhere where you take COE and mix it with projects and so on. There is no way. There is conditional grants for services. So it doesn't work that way. Including the funds in municipalities, they are properly managed in a manner, and they are being audited as well. So there is no way that you can take money from compensation and take it to services. Doesn't work that way. So I'm just saying, let's not find reasons why these municipalities, let's know what exactly is happening. They must give us the report, and we say, okay, this municipality, then it gets reported to Treasury. Treasury must find a way of dealing with it. So we know that this is what, because some are actually paying. But you get this fund management managers as well, they've got their own interests. Not that they've got interests of those that are employers and so on. So I think we need to have that systematic and say, this is how we're going to deal with the matters. so that we don't, say maybe, you said you've got enough regulations, you've got enough law that empowers you to deal with this. So let's not look for something else. I think it's just a systematic way of dealing with this matter so that we are able to ultimately get these fund managers to be responsible and accountable, because they are dealing with people's lives here. So I don't think we needed to try and find another law unless you are able to pinpoint that the law is insufficient here and we can't deal with it. So let's, within the law that we have, let's find a way of holding this admin fund managers accountable to these members. So with municipalities, definitely Treasury needs to take that responsibility. But out of the report that is given from municipalities as to why, because others might find that they have actually paid. And so, but we are making assumptions. So, well, with Free State, I'm sure my fellow comrade here can deal with it, because that's another batch of municipalities. The issue of, I think my colleagues have already spoken in terms of the issue of the admin fee that the members are made to pay, which is very much ridiculous. I mean, honestly, these funds, they're already benefiting out of managing those, Now, it means they are already paying admin. They're paying for them to manage the funds. They're already paying. Now, it means they're actually, double DP. And I agree that we need to find a way of dealing with it, that at least there must be a measure that will say you can't go beyond this percentage, or you can go. Because then it would mean that these fund managers, they've got unclaimed funds, they still charge and all these things. So it's, for me, it looks like, it's just a Christmas every day with this, fund managers. So I think we need to find a way to normalize these funds. And agree that perhaps we need to get, quarterly we get reports in terms of how we are dealing with these issues. So that we are continuously updated as a committee in terms of what exactly actions are being taken, and we must see what being able to account. Yeah, I think, but also have a very clear report from the pension fund adjudicators in terms of the prescribed, amounts. What could have been the amounts and what are the issues, so that we know also what happens when they get prescribed and when they are terminated, what happens with those funds. So that we don't have members or employers as well contributing, but finally they get terminated because of whatever issues that might arise. And because employers don't have children and wives and husbands, it's the members who get to suffer. So we need to really find a way of dealing with that. And lastly, it's this unclaimed funds. I don't know how we are going to deal with it, but I think there's a need to find ultimately a solution to these unclaimed funds, because they did not get themselves there. We must find, a very clear report as to how did they get to be unclaimed. Is it interest, or what actually happened, and how are they going to be dispersed? Because it can't be that they sit there until what happens. Because then it means that it becomes funds for those managers. clearly, if we don't know where they'll end up, it's a problem. So I think we need to as well find the ultimate, fate of those unclaimed funds. I think I'll pause there, Chair. Thank you.
Thank you, Honorable Scott. Honorable Alexander.
Thank you, Chair. The joys of going at the end, most of the stuff's been asked. Just a couple of points of clarity. The Minister of Finance in March said 149 municipalities had not paid over their contributions, and the amount quoted there was 1.4 billion rand. And I'm not sure if I was misunderstanding the graphs and everything, but that's 3.9% of the non-compliance, where the security companies are making up 36% of non-compliance. So, like, what is the real value then that is not being paid, that is outstanding from pension funds? If municipalities are looking at 1.4 billion and they are just under 4%. There was also a comment made that so the pension fund says that the employer must pay over, and if that's not done, there are penalties and fines and criminal actions, but it involves somebody reporting it to the police. And we're hearing that umbrella funds will send termination letters. Like, isn't this a loophole? Like, is that enough? Like, it's been spoken about a lot today, but this doesn't protect the people that are going to draw from their pensions if there's a termination letter on a file somewhere, but the pension fund hasn't been paid. This has to become a criminal matter, or the regulation has, the regulation talks about responsible persons. Who are those responsible persons? And perhaps this is where the regulation needs to be clearer around that. And then just again around the Auditor General, are they picking up these non-compliances, and is it being reported, especially in the municipalities, for us? And then thank you for the detail that we got around which potential pension funds aren't paying, some of the municipalities. But the other interesting information would be, how long have those municipalities been non-compliant? Has it been, because the law says 7 days. So is it days, months, years? And what is those amounts that is actually outstanding per municipality, so that it becomes like a report we can track over time? Thank you.
Thanks, Honorable Alexander. Honorable Khaya.
Chairperson, thanks very much. I've been largely covered by honorable members here. I'm going to restrict myself to only one question, which has to do with the safeguards and the remedies that are there. If you go through the presentations, you have a list of complaints that have been registered. Very few of them have been resolved. I do not know. I mean, what is the social standing of the people who make these queries or register these complaints? Given the difficulties that we have of escalation of the cost of living, what measures do they resort to if they don't get relief? Do they contract the services of professional people in litigation to pursue their matters, where they end up incurring unnecessary costs, where their problems could easily have been resolved? And what penalties are there for these institutions that are failing to make contributions? If you say you have 69% of municipalities coming from one province, which are in areas, I can imagine, well, what does it mean? If a person wants to claim, or a person ends up dying without getting their monies, what does it mean? Have we, because the presentations that have been made here do not go to that extent.
we have not been introduced to a situation where X number of people have tried to claim, their claims have not been paid, and they ended up passing on without. I want us to go beyond the numbers that we are being presented. Because let's interrogate this number. These numbers represent human beings. Or behind these numbers, when you present numbers, numbers can just be very cold without telling you the real difficulties people behind these numbers are facing, whether there was one with a child at a university, the child now had to drop out of a university because the father or the mother is deceased, and a municipality or one institution has not paid its third-party contributions. Are we able to go beyond the cold numbers that are being, so that we, when we are here, we represent people, not numbers. You walk in town, somebody grabs you by the jacket and say, I've not been given my money. So if we would know, if it's possible for us to know, you can share with us that information so that, like Honorable Scott was saying, if there is because of the inadequacy of the law, let's find a way in which we improve the law and tighten it so that it can protect the most vulnerable. It's very, very difficult. I mean, if people want to claim and they cannot get their monies they have worked for many years under very, very difficult circumstances, and that also end up affecting their dependents. I don't think it's okay. But unfortunately, the presentation doesn't go to that extent, but I would have been interested to know what are the safeguards and the remedies that we will have to an ordinary person who does not have to go and incur extra costs because they want to get their money. Thank you.
Thank you. What I hear members to be saying, National Treasury, FSCA, and Adjudicator, we have had an induction earlier this year. Today, we are not in an induction. We are in a situation where we must implement the law. And we are not going to leave this meeting just issue a statement that we acknowledge. We are going to leave this meeting taking a decision with you. Treasury says, Pension Funds Act through Financial Services Laws General Amendment Act of 2013 strengthen governance in retirement funds by making non-compliance with Section 13A of the PFA, which deals with the payment of contribution fund to the fund, a criminal offense, punishable by a fine of up to 10 million or imprisonment up to 10 years, holding the persons and the employer responsible for not paying the contribution over the fund personally liable for non-compliance. The PFA places the responsibility for ensuring compliance with contribution on the boards of funds. So, this is what the law says. So I don't think, Sister Alvina, you can come here and tell us to pass another law. I mean, in 1 year, how many bills do you bring here as treasurer? Last week, this week we'll be dealing with 5 or 6 bills, tax, only from treasurer. So the other law, let's park it for another day. Let's talk about what the law says. Tell us, the two of you, we are going to issue a statement after this meeting. That at the meeting that we met with FSCA, National Treasury, and the adjudicator, these are the actions that are going to be taken. We can't have a state which protects the financial institutions. So you say there's law for the most powerful. That's what you're saying. And there's law for the vulnerable who are not protected by anybody. If the state does not protect the most vulnerable, where should they go to? Come out clear. Don't tell us about another capacity building, another law. Tell us about what you are going to do with what is provided for now in the law. You can't have pension fund administrators behaving like Woman Shonisa, charging admin fee. Is it there in the law that we passed this parliament, which was signed by the president? I haven't seen it. I haven't. Why do you allow that treasure? That anybody can wake up, I charge you 20 rand. That is done by Machonisa. If I borrow you 10 rand, you bring it back at 18 rand because it's not that properly regulated. We allow it as government in a democratic South Africa. And we say, no, they are doing it. They are doing it. Please, just be strict and be clear of the actions now. Don't tell us about, hey, we want to come back with capacity building. We're running short of what? No. Today we're coming for action. We get calls every day as members are saying, vulnerable people. Maybe it's because they are not our parents and they are not our brothers. Hence, you can't feel the pain of somebody who have worked for more than 40 years, is about to retire and be told there's nothing, including government. What kind of a country is that? Government. And we keep quiet. We'll have a meeting with Minister Tlhabisa, Honorable, but for now, the law is clear of what must be done to those who are non-compliant. We can't keep having many meetings. This meeting is highly, there's high expectation from outside. There's a lot of publicity about this meeting. You remember even that day when Minister Sputla came to present at ETC, we said that we are going to have this meeting to deal with this problem. So we can't live here. If you want us to have break while you discuss, you can allow us, we'll go out and drink tea. And then you tell us that we are ready. Yes, we're serious. We are not here to play. We have been elected on the 29th of May to come here and represent, more especially the vulnerable who don't have money to go to courts, unlike these big companies that we are talking about. This one can take you to court 5 years non-stop. But the poor don't have even money to buy food. You know, the cost of living now in South Africa is very high. Very, very high. Maybe it does not affect us who are here in this room because we earn more than 350,000 and above. But to those who rely on grants and they are working there, I mean, I understand that there's challenge with the security companies, but for them not to pay even a cent on a contribution, that cannot be condoned. We must take action for everybody. They will speak for themselves either in the court of law or somewhere else. I think that's what is going to happen. So over to you. Let's start to, in that order that we started. PFA.
Chair, thank you, and honorable members for the question. Mine a few, so I'll start with that. The first issue was around the administration capacity of the private security sector provident fund. I think on my presentation, I referred to 3 cases because you referred to the process that was followed to appoint the administrators. And those 3 cases actually deal with that. They indicate that the FSCA did an investigation and then and that investigation is what led to the removal of the board. But in the cases are very short and written in a conversational manner and easy to read. But they indicate that the fund actually knew at the point of placing the administration with the current administrator that this administrator had no capacity. So there was bribery, there was also, they first did a closed tender. Then once they did a closed tender, they changed the terms to lower them even further for this particular administrator to be able to tender and meet those. And then afterwards, with the investigation, they then discovered that money changed hands between some people and the people that were on the board and their related companies and that. And that is why when they tried to fight the sanctions from the regulator, removing them, the FST was of the view that in actual fact, you should have had more sanctions against you because what went on was just pure criminality at the end. But it still leaves the members with the problem that this administrator will never have the capacity to administer this fund. That is clear. From the time the fund was placed with them right through, they will, with all the myriad of problems that continue to crop up, they will never reach the capacity to be able to administer the fund. One of the things that you would have seen from the slide from the FSCA was that they've got so many active members and their inactive members almost outstrip their active members. That gives you another problem of what? Of unclaimed benefits. And what do they then do? They go and they form an unclaimed benefit funds. The monies they get transferred in there. No one has an incentive to go and look for those members because the members would have knocked at their door so many times, they give up and they move away, they leave their money. Years later, and while the money is sitting in there, they deduct admin fees because the money is sitting in there. Then afterwards, they go and get someone to come and trace those people. Then the person comes, complains to us and says, but they traced me. They said, I've got 5,000. The tracer has charged 3,000 to find me. So I'm only left with 2,000. That is the reality of the people in that fund. So it just requires some other solution. And Chair, I know that you are saying what dedicated capacity and all the members. We do need, if what the Deputy Commissioner has said relating to the ecosystem, you almost have to trace what brought us here, because we are able to form a picture because over the years we've been collecting the data, analyzing the data and doing all of that. So you need all of us as role players to actually do that and say, what is it that we are dealing with? We can't do it with our current staff. They're busy with other things, but we almost need to follow through and say, what did Fund A do? Did you go to the police? Did you do this? Why would we have registered a rule that will have such harsh unintended consequences where a fund can just write you a 30, 60, 90-day letter and then terminate you? Is it the rules? They are not doing anything unlawful, but what is the effect of that on the member? So there are certain things that are unintended consequences that we have to study and then correct while we are bringing up the problem. But with current capacity doing all this and that, we will lose focus again and come back and say National Treasury bring another. If we are of the belief that the current law is sufficient, then we should be given an opportunity to go through dedicated capacity to say, what is it that we can do if we concentrate and try and resolve this problem? How far can we get? And I think that is where I'm coming from with the dedicated capacity. Otherwise, we will continue also to have this problem of unclaimed benefits. And yes, there was a question about PSSPF not being a new problem. So what have been done to date? I think part of what was done is the investigation that was done by the FSCA and then brought in a new board, but that's at governance level. So now the issue has to be with the outcomes for the members. Are we improving those? And you are correct. If you look at, which is the question that goes to why with municipalities with those numbers, it's only so much money or percentage. And in the other funds, we are dealing with members that are earning a lower amount of money. So these are people who can't even go to the employer and say, you are not contributing, because by the time we complete dealing with the complaint, the employer would have dismissed them. So because the funds are not doing what they are supposed to do, they are actually also placing the members' welfare and their employment and whatever at risk. And that is what we see in all these funds. You saw them, contract cleaning, private security, all those ones. And that is why the percentage is so much lower in terms of what is outstanding, because the salaries there are lower. In the municipalities, the salaries are higher. That's why you see it at 1.4 billion. But the effect on the most members is on the people really whose social standing, who actually depend on all of us here to do the right thing in order to protect them. The question around yes, in the private security center, we have not looked at whether the employers are being paid CIRA rates by the government. What we have come across is where government departments have actually not paid over for the services that they have received from security companies. I'll give you one example. There's a big company that operates called Mafuko Security Services. They were doing well, paying and everything and that, until in 2021, ESCOM failed to pay them. And that began a whole problem. By the time ESCOM started paying them again, they had accumulated so much in interest and all of that, that complying then became a problem. But they had been complying all along and trying to do the right thing. Now then they left the private security sector fund and went to start fresh in an Alexander Forbes fund. That fund terminated them in 2021. They are only now paying 50% of the liquidation benefits after 3 years. And what happens to the other 50%? The members will scatter, and then it becomes unclaimed benefits again. But they fell into arrears because an SOE failed to pay them. And where would they get the money now to do all this? Because now they must even have money for salaries. So it is true that the sector depends on up-to-date payments. I'm not excusing the fact that they have not paid, but there are real problems in terms of when this, because they are small operators also. When they don't get the money, the cash flow is affected immediately and they can't meet their statutory obligations. Let me not touch on the other issue. Maybe they'll cover me, the colleagues here. And on the issue of prescription, yes, they will have to, I think the FSCA will have to work out what of those amounts have prescribed. But what we try and do is, before we say a claim has prescribed in our judgments, we try very hard to find whether there isn't one of the issues or that can interrupt prescription. So we look at the case, we'll try and see, was it reasonable for this member to not have known about these things? So we'll always go as far into the law as possible to try and see whether prescription has not been interrupted or not. But when a fund comes to complain about outstanding contributions, it's not possible, because the fund knew from month one that the employer didn't pay contributions because of the way that the law is. But if a member comes to complain, it's a different thing altogether. The member can say, I didn't get pay slips, or they can say, I was seeing the deductions of the pay slips, so I was unaware that these deductions were not being paid over either. But for a fund, it's impossible. So where a fund complains, the 3-year time period is just like that. And we are not in law. It's not for the person who owes me to plead prescription. I am barred from entertaining a matter that has prescribed. So our statute is that I must establish jurisdiction first before I can deal with a matter. So it's not the other. Once a matter has prescribed, I can't deal with it. It's time barred, and I must establish prescription. They don't have to come and plead it. I must be upfront with it. So that is also a limitation. And one of the things maybe that Treasury might look at between us and the FSCA is that our office is not empowered to deal with systemic issues, and this is a systemic issue. So if an employer has 100 employees, all 100 must come and complain. If one complains, I can't go and say, because this one complained and I found that it's outstanding contributions, I'm going to look into this employer altogether. I can't do that. So I can't look into things that were not brought to our office. So that is a limitation maybe that we might look at going forward. I think that I have handled all the questions. Thank you.
So Pension Fund Adjudicator, what I hear you to be saying is that there's nothing that you can do. I hear how you are analyzing the law, which we understand, but I didn't hear you saying anything about the action that has to be taken. So if that's what you're saying, just tell the community that, look, we as the Pension Fund Adjudicator, there's anything that we can do under these circumstances. So that is very clear, and it is on record. The issue of capacity, I think government established entities. This is the work that was supposed to be done by National Treasury. But above that, National Treasury established entities so that they are specializing on these specific responsibilities. So what I hear the PFA is that under these circumstances, we can't do this, we can't do that. We don't have capacity, so that we record it. It should be in the record of the committee that there isn't much that you can do under these circumstances. Because Tina, we can't leave this meeting with just saying that we noted lack of capacity, lack of this. Then we'll see in February. We want to leave here with a clear resolution as a committee. Back to you.
Chair, thank you, Honorable Chair. I think from my side, we will go back and work collaboratively with the FSCA, the AG. I mean, the intervention with the AG also includes us. But I think without me saying what exactly those steps will include, we are, and this is really not an excuse, but the facts, we are restricted by our mandate. We are a creature of statute, and we can only do that which we are empowered to do. As I sit here, all these other things of collecting the data and all, we have actually already gone beyond what we are empowered to do, because we are only supposed to resolve complaints in terms of the law and do all of that. So our office has a lot of data and a lot of input to make in the solutions that we can all bring to this. And I would like to defer to those processes in order to be able to exercise our powers within our mandate. So we will participate fully in trying to find a resolution to the issue, but we are really, really constrained by our mandate, if that's specific.
So, what is your mandate? Can you workshop us under these circumstances in which we find ourselves? What becomes your mandate? Is to collect data and hand it over to FSCA? Is that the only mandate of the PFA?
Our mandate, Chair, is to resolve complaints. What we then do over and above resolving those complaints in terms of the Act is to supply the regulator with the kind of information that we see in order for them to be able to regulate the industry properly. So all these systemic issues that I'm indicating to you, the FSCA does plug into our system, even National Treasury. We report to them to say, this is what we see beyond our mandate. So we do supply them with that data and engage with them on what sort of solutions we feel can be put in place to try and resolve the issues. But our mandate is quite restrictive.
Okay, let's go to FSCA.
Thank you, Chair and members, and thank you for the incisive questions that you've all asked. So I'd just like to make a general comment before I answer specific questions. We did not come here today to say to you, this is a problem that we can't solve and that we don't have resources to solve or that we don't have powers. We came here today to say to you that over the past 2 years, we've been gathering data on arrears. And since we've been gathering the data, 1,000 employers have paid. So if you think that 7,700 employers are not paying, a year ago, 8,700 employers were not paying. So in the past year and a half, we've already made a substantial difference. We'd also need to be very careful when we in understanding the magnitude of this problem. So remember, it is 3% of all the people who pay pensions who are experiencing a problem with arrear contributions. So the system works for 97% of the people. We're saying we've got a specific problem, and these are the people who are causing the problem, and these are things we do. The area where we don't have powers is right now, we have criminal sanctions in place in the law. We have authorities that deal with criminal cases, and we have seen some cases very recently where steps have been taken, people have been arrested. So it's not that we're not seeing results as a result of these actions. However, the pension funds are the ones that need to take the matter to the police. The police need to understand that this is a serious issue and then complete the case and hand over a proper case to the NPA, and then the NPA needs to have the resources to take it further. What we're saying is the only gap that we have legally at the moment is that we can't go to the police and lodge a case. Okay, we need to get the pension fund to do it, and that is the legal change that we have put into the Kofi bill, and that will hopefully come to you. So our appeal to you is, when that bill comes to you, please give us those powers so that we can actually go to the police and take things further. I think the other thing I wanted to say about costs, and I'll come to the specific issues, is that I don't think there's such a thing as a free lunch. We all, for a service that we receive, there needs to be payment. But what we want to make sure is that that payment, that cost, is a reasonable cost. And that is something we think as a regulator, we should be evaluating, and that is what we're doing. We're evaluating at the moment whether the costs that have been charged are reasonable. If we think that those costs are not reasonable, then we think, yes, we need to then explore whether capping fees or fee regulation is necessary. But that again would be a legislative change. That would not be a quick solution. So from our perspective, what we've been trying to do as a regulator is to say, within the ambit of the law, what are the powers we have and what can we do? And we think actually making things public is very important, because if we hadn't made a publication, we wouldn't all be sitting here today discussing this very important issue. And because we've been raising this issue in the public domain, the AG is now actually specifically looking at the failure of municipalities to pay over. So yes, it's not a new problem, but remember, it's not only a problem that we experience in South Africa. And in fact, Serena and I've just come back from a meeting of international pension fund regulators. This is an issue that's experienced all over the world. And yes, we can learn from the best, but at the same time, many of them are not doing the things we're doing today. So naming and shaming is a new thing. And we are, in fact, engaging with other pension fund regulators around the world to say this is something that you should be exploring because we've actually seen concrete results. And I don't want to, I think we mustn't underestimate 1,000 employers coming forward and making payments. That is something that has actually made a significant contribution to people's lives. All right, so let me just then talk to some of the other points. So, Chair, I think that the only thing we would say is give us time to finish our review of the fees. If we think that there's a need for fee capping, we will come back to the committee and say so. I don't think we can say that the problem is this big at this point in time. As the PFA has said, it does need to be informed by evidence. Okay, so we're happy to come back to the committee and give you a full report on that. On the arrear contributions, what we think is what we would appeal to the committee, and if the committee after this meeting today says you think this is important, what we would really appreciate is if you could say it's important that the FSCA has direct powers over employers. So let me just come back to some of the other points. So we have identified the funds that are the most problematic, and those are the funds that we deal with. We have what we call a war room, and we've put all the information together. We have different teams from the FSCA that are working on those issues, our enforcement colleagues, our legal colleagues, and we put all the data in there, and that's how we deal with the problem funds. So, you know, you will get feedback. We're very happy to come back to this committee regularly and provide you feedback on what we're doing about each of the individual funds. The PSS, PF is at the top of our list, but at the same time, we're engaging directly. We've engaged with the National Treasury about municipalities. We're engaging with the AG around municipalities, and we're actually engaging with the municipalities themselves as well as the funds to bring them together to find solutions to those problems. So we're definitely not here to say that there's a problem that we can't solve. Then financial literacy is very, very important, especially around two-pot. It's been absolutely critical. And I think actually quite a lot of expenditure has gone on that. As the FSCA, we've had our own campaigns, and I can ask my colleagues to talk about that a bit more. But all the funds have had to have campaigns. We engaged with all the administrators, and we actually even reviewed some of the material that they provided. But let me, I'll ask one of my colleagues to talk about that a little bit more. So just, there were questions about criminal charges. Yes, there have been charges. I think there have been 3 cases, and we can certainly share that with you. And the non-payment by municipalities certainly is a crime. It's no different from any of the other cases. It's regulated by the Pension Funds Act. And in fact, the 3 cases, the 3 arrests do relate to municipalities. It's municipal managers that have been taken to task. The non-compliance by employers. So this is the issue that the boards need to deal with. They are the ones that take the matters to the police. And yes, we monitor. We ask them, what have you done to deal with these particular matters? And where we find that the boards are negligent, I think as the PFA said, we have removed the boards. We have also held them personally liable at the the tribunal, and these are issues that of course are contested, and we do spend a lot of money on legal issues, because when it comes to money, people will always it will be very litigious, let me put it like that. I think the so the question about the 19 active member, 1.9 million active members versus the the total number of members versus the active members. So the total number of members would include pensioners, for example. So you're still a member of a fund if you're a pensioner, but you're no longer actively contributing to it. So that would be the distinction, or yeah, that's that distinction in the law. And then in the financial education issues, why are people claiming at an early age? I think a lot of resources have been spent also by funds to highlight to people what the dangers are of early access. I think you can never have enough financial education. And in fact, I think one of the things that it's occurred to me recently that we do provide for kids that do math lit, for example, at school. I had one. They do provide information. A lot of that is financial literacy. So, and they do learn about pensions, contributions, how do you read a statement? I don't think that we do actually enough about that, about that as a country. And I think from our financial education responsibility, it's one of the things in our mandate. We're definitely going to engage further with the Department of Education. We already have a very good relationship, but I think this is part of the curriculum that probably needs to be extended. Of course, the other part where financial education occurs is at the employer level, as well as through the funds. And I think for us, this is a growing area of focus, the pension side. We've had a much broader responsibility already. I think I'm going to just ask Zarina to talk about prescription and some of the other questions that are of a more legal nature. So, there were questions about the reports by municipalities. So we get reports from the municipal funds that tell us which employers don't contribute. So those are the reports we get. We don't currently have any authority over the municipality. So we can't say to them, you must report to us. If you give us the powers to do that in terms of the Kofi Act, we will be able to ask that. For now, we have to speak to the AG. We can speak to them, but we can't require them to give us that information because they're not a regulated entity in terms of our legal framework. And yes, we're very happy to report on what we do on these issues. So we're very happy to provide you with a very systematic report that says, these are the problem funds, these are the steps we've taken. We can't necessarily tell you these are the steps that we're going to be taking because sometimes, especially if those are legal steps, we can't tell people that those sort of things in advance, but we're very happy to share anything that we can. On unclaimed funds, I think that is unclaimed benefits. That is probably a whole nother discussion. It should be a whole briefing, Chair, on unclaimed assets. What I can say is that we're working very closely actually with Treasury at the moment on a concrete proposal around how one deals with it. There is a lot happening. All the problems that you've mentioned are the problems that we are aware of. And we think that, that there needs to be a different solution. And that's what we're working on. And we hope that the Minister of Finance can make an announcement on that. I know I've rushed through the questions, but I think I'm going to just ask Zarina to come in on some of them. If you particularly could talk to prescription as well, Zarina, I think that would be useful. And what steps we've taken on the trustee governance issues. One last point that I did want to make is on the PSSPF. It's the arrears on the PSSPF at the moment are 2.4% of the value of the fund. Okay, so it is significant in terms of the number of complaints and the number of the extent of non-compliance, but in terms of the value, it is not something that threatens the existence of the fund. It doesn't mean because it affects individuals, it's very, you can never minimize it because it is an individual's pension. But it is not something that would prompt us to deregister the fund. Okay. I don't think, and deregistering a fund would put all the people who have money in the fund at a disadvantage. So I don't think that's an option for us unless there's no money in the fund. That's the only time we cancel or deregister a fund. Oh, and then one last question also on the just the value of the area allocations. I think our presentation may have been a little bit confusing. So the 3% of municipal funds, that 3% figure related to the number of funds, not the value of the assets. So what you've seen in the diagram is percentages based on number of employers, not the value of the arrears. Okay, Serena, over to you.
Colleagues, I hope you can hear me now. So I'll probably just start with, I think the Honourable Member Van Rooyen asked about, what we've done about financial literacy, particularly around the two-pot system. So what we had an entire awareness campaign on this. We basically approached the trade union federations. So we've had awareness programs to the shop stewards of COSATU, of SAFTU, as well as of FEDUSA, to reach as many, obviously, we approached the shop stewards councils so that the message could filter down. So we think that was quite effective. And even though we're sitting here today, and I know it's maybe not the most comfortable for some of us, I also think what's really critical and what is played out with the two-pot system or two-component system is that members now have a very vivid idea of what is happening in their funds, which is actually something which is really positive. And that's another, really a positive takeaway. Because before, as the adjudicator also explained, often members come, when they resigned or they've retired, and then they learn there's nothing in the retirement funds. Now it's a very different story. The narrative has changed considerably because now members want to access their savings withdrawal component, and then they learn that there's nothing in there or less than anticipated. So there's a great education, and even if you speak to administrators, what they've noticed is that before they didn't even know whether members were reading their benefit statements. Now members apparently check it virtually every day because the apps allow them to check. So there is that vigilance, and that's really, I think, an important upshoot of the two-component system. But also, Honourable Van Rooyen and other honourable members, we've also opened that door. So we have said whoever needs, any awareness or education, we are there for that purpose. So if webinars are needed, we can be approached. Again, also the door has remained open for COSATU, for SAFTU, for FEDUSA, for all the trade union federations, because we think that's where we can, with our resources, probably make the maximum impact. And also just if there are any concerns, just to assuage your concerns, I know that, Chair, you were saying, we're sitting here, maybe we're not impacted, but remember, we come from families, many of us, who are, working class. And I think that for us, it's very important coverage and that workers get the benefits that they deserve so that they can retire, with dignity. So I think it is something, the severe contributions, I hope that there's not an impression that it's not something that we take incredibly seriously. I think we really take this to heart. It's an issue for us, and we are putting, together whatever resources we can to actually address this problem. So that's on, dealing a bit with the financial literacy issues. And just to augment what my Deputy Commissioner has indicated, so I 100% agree with her. If you look at international best practice, for example, on education, I mean, some of the regions that, or, countries that basically have optimal financial literacy, it actually starts in kindergarten. If you look at countries like Singapore, if you look at countries like Hong Kong, that's where they start. So it's not even in high school as we have with maths literacy at the moment. So I think it is something that we need to look at and that we need to engage on. So that is on the education side of it. And of course, we've worked very closely with our consumer education department on developing infographics, because not everyone wants to listen, to people droning on perhaps, but maybe, an infographic is some digestible material. You chunk it down and it's more easily consumed in that fashion. So just also speaking to, again, I think it's because I think Honorable Van Rooyen asked quite a number of questions, but again, to augment what the Deputy Commissioner has said, you've asked whether, with the perennial problem that PSSPF has provided, should we not deregister that? As we're saying, it's important for us that coverage of workers are increased for pension benefits. I think it serves the social function. And of course, as I said, we believe that every worker should retire, with dignity. So if we deregister the fund, so say in a fund of approximately 300,000 workers or members, and even if it's 150,000, you have them covered and they have their risk benefits in place. I don't think it would be wise or sage to actually deregister a fund, because then you're disadvantaging 150,000 workers. And as I said, coming from working class background, some of us ourselves, we know that each worker basically has 7 dependents who rely on them. And that's why, Chair, it's our submission that it's not particularly something that we would want to do to register a fund. I think what is more critical is for us to actually get employers to a state of compliance. That is the aim. And that is what I think collectively we can do with the Adjudicator's Office, with the AG, with SARS, with National Treasury, and various stakeholders that you've indicated. And look, we are doing that. We are engaging, as has been indicated in the slides, we're engaging the employers, employer organizations, bargaining councils, etc. So that has been done. On the issue of prescription. So prescription is, yes, employers may raise prescription, but I think it has been touched on by the adjudicator as well. But there are factors that interrupt prescription, as you may know. So if a member didn't know, for example, so if they say, I've never, as the adjudicator said, never received a pay slip or never received a benefit statement, and they only became aware when they lodged the complaint with the adjudicator, at that point that they didn't have the funds, then the employer cannot effectively raise prescription, because it's only when you became aware or ought reasonably to have become aware that prescription can be raised. Also, it's not, prescription is one of those defenses that you actually have to raise it. It doesn't arise mero moto or of its own accord. So the employers actually, and they would have to have a lot of guts, and I think there'll be a lot of pushback by members. Also, it's also useful. I think that's where trade union federations and trade unions play a very important role, not to allow these things to happen. But of course, so that is on prescription. And of course, from our side, we also look at what we can do, even if matters have prescribed. So that is also something that we have looked at. On the trustee governance side of things, and my colleague Korea is also here, when boards don't do what they're supposed to do, we have the powers to actually replace that board with a Section 26(2) board. And that has happened. It's not that it hasn't happened. Again, also, as has been alluded to by my colleagues or indicated by my colleagues, PSSPF, which is one of the, huge recalcitrant funds that we have, a statutory manager had been appointed. We hear the adjudicator saying that even the new board doesn't do what it should do. And there are challenges with the administrator, and it's not as if we're not looking at it. Those are precisely the issues that we are looking at in the war rooms that have been established at the FSCA. So a lot, yes, we probably should have done more earlier, that I think we can say. However, I think a lot is being done now to arrest the problem. And it's also not that nothing was done over the years. As the Deputy Commissioner has indicated, data was being collected, various strategies were looked at, what we could do. Naming and shaming has happened, which has had quite a very positive impact. We are engaging, you've also asked questions about best practices internationally. We are engaging our colleagues on the continent, our colleagues internationally as to how they've dealt with it. But it appears that we are on the right track, because the naming and shaming is something, as the DC said, which is, in fact, they actually have looked at us to say, that was a very good strategy to have employed to get a level of compliance. So as as has been indicated, we'll continue with that. We'll continue with a plethora of other things as well. We have been engaging the National Prosecuting Authority because, of course, there has been challenges when funds do go to the South African Police Services, where they may not have a good understanding of the fact that this is a statutory crime. So that has been one of the weaknesses in the system, and that is where administrators and funds have said that this is the challenge that we face. When we go to SAPS to report this as a crime, SAPS doesn't see this as a crime. So obviously that is something that we are addressing, but we are addressing that. And we are addressing that with the NPA. The NPA has also indicated that they are willing to take our cases. So we've had a very constructive meeting with the NPA, in fact, during the course of this month, where they've indicated that they are happy to take forward a number of our cases. So, it's truly not a case of us sitting on our hands and doing nothing. I think we're making a concerted effort, and I agree that the concerted effort has to be a collective one. But that is, where we are. So thank you for your attention.
I think when the treasurer comes, it must be very clear what the two entities must do, because they report under you. You read us the act here. What must happen? We are serious. Whether it's 1% affected, not in percentage terms. Because we'll say it's 3%. 3% will translate into how many people? Because we're talking to somebody who's here in Plain Street and is retiring tomorrow, and is here in Parliament as a parliamentarian. I'm retiring with nothing. So let's not emphasize percentages that it does not affect much the funds, and let's talk about individuals who were not voted in percentage terms, who were voted by a person who didn't sleep, woke up at 4 in the morning and said, these honorable members are going to speak for me in Parliament and protect my rights. So all that Treasury you have gone through about what must be done, who should do that, when, so that there must be clear actions coming out of this meeting of what we are going to do. Because if FSCA is serious, they write letters and tell you that tomorrow we're closing you. You wrote letters to Italy. Why are you not writing letters to these people who are causing problems? You must do that. You can't massage people who are violating the laws of the Republic and causing people to take their lives because they will retire with nothing. No, we must be very serious. I'm telling you, as I said, there can't be a law for financial institutions, unclaimed benefits. This is a lot of money. It's a lot of money. This goes into billions. Treasury, what are we doing with this money? So insurance companies, banks, just use this money for themselves. Is that what the law says? And people, for some reasons, disappear who are supposed to benefit. They can't even get the beneficiaries of those people. So money is lying there. what do we do with such unclaimed benefits? And what do we do with culprits? As I said yesterday, I read the story of what FSCA has done. Fine, you have exposed those ones, you publish their names. They don't care. They are used to be exposed. But now we must follow with clear actions out of this meeting. So Treasury, come and tell us after the two entities have responded. You are the custodian of these laws. It's not them who brought this law here, it's yourselves. And we passed this law under very tremendous pressure, thinking that is going to alleviate the lives of people. But now Alexander Forbes comes to a meeting of parliamentarians and tell us on our face that we are charging admin fee. Based on what? It's based on which law? That you can just wake up and charge admin fee. So all these administrators have got their own fees that they're charging. And Treasury doesn't see anything wrong. We must wait for coffee bill when people are being charged money now. It can't be. So you must tell us what we must do, leaving this meeting, taking actions, clear actions, clear that this is what must happen. And we are going to issue statement out of that, National Treasury.
Thank you, Chair. I thought you were going to give us the marching orders, but let me try. So I think as FSCA has mentioned that there has been literacy and an outreach when it comes to trying to educate members. That's something that Treasury feels should continue. It should not end now with the two-pot system being in place. It should be a continuous effort to educate or to inform members about their funds. And as the FSCA has mentioned, members are now aware. Before, there were members that were not even aware that they were contributing to funds. Now they would be actively involved. With them being actively involved, they need to understand the impact. Firstly, the need for a retirement fund. That's a long-term saving measure, but we have as government opened it up for some emergency. So they need to understand that you tap into that two-pot system or that savings component only in dire circumstances, not just monthly use it as a bank account. And also know the implications that when you tap into the system, what happens? That's the fees, the costs, and then you taking from your future self. So that's what I would say, that first thing that we should do, continue with literacy and awareness in terms of retirement savings. From government side, we need to bring on board COCTA and Treasury in terms of measures that Treasury can put in place for municipalities that are not up to date with their pension contributions. From the FSCA, the talks have been started in terms of SAPS and NPA, their capacity, their understanding, retirement savings also, the law that is in place so that there is proper enforcement. This one, Chair, you won't like because you are entertaining a lot of legislation from us, but unfortunately, the Pension Funds Adjudicator has mentioned a gap in their mandate, which might need Treasury to action. And for us to action, to give her that mandate, we will need to give her legislative powers. Secondly, the FSCA has also mentioned a gap on their side in terms of enforcement, that they can not only rely on SAPS and NPA to enforce. Can we give them some powers to also directly have standards, have regulatory measures on the employers directly? So I think that's what I would propose from Treasury's side that we would do. Continue with education measures. Treasury engages with COCTA on measures that can be put in place to curb the municipalities that are not paying. FSCA to continue engaging with SAPS and NPA on their capacity to enforce, and for Treasury to give the necessary powers to the Pension Funds Adjudicator and the FSCA to ensure that this problem does not persist. And lastly, I think something that can be done now, the FSCA is able to issue conduct standards. We do have a conduct standards already. I think it's one on yes. So that maybe we need to look into it in terms of boards that are not reporting. Because chances are maybe you see it in the financials, but they haven't reported. So those steps that after, I don't know, 60 days, 90 days, have they done those, or do they wait? So also we need to ensure that boards do what they're supposed to do, rather than just removing the board and then you have new people that come in to continue with the same problem, or the employer just decides, I'm leaving this umbrella fund. The problem is still not solved. Thank you, Chair.
Claim benefits and admin fees, what do we do?
Oh, sorry. So I will have to engage with the FSCA on the fees. So unfortunately, it's in the law that there has to be a fee charged for the service, retirement savings service. It doesn't say though what should be charged, how it should be charged. So we need to engage on whether we address that through some form of conduct standard once the assessment that the FSCA is undertaking, once they've received the information on what is being charged by who. So we'll engage with the FSCA on possible measures that we need to put in place, whether they issue a conduct standard, or we start with some form of disclosure and transparency, if that can nudge some form of making sure that there's an alignment, even though there might be competition issues there, we're opening ourselves to competition issues, that funds, there isn't those many outliers. On unclaimed benefits, a process has been started by the FSCA. They've issued a paper that seeks to centralize. One of the proposals is to centralize unclaimed benefits. So what the Deputy Commissioner mentioned, that the Minister will be making an announcement, it's where and how to centralize those unclaimed benefits, and also the tracing. If it's indeed happening, if we need to ensure that funds do trace. And another issue there that the adjudicator raised, it's the fees around the unclaimed benefits, where they are held by funds or administrators and they kept on being eaten by the fees. By the time the member is traced, there's nothing left. So the fees go beyond just the two-pot savings withdrawal fees. It can say across the board. Because we do get our benefit statement. What I see is what I can get when I resign, when I retire, or if I was to withdraw. Fees are not disclosed there. So the issue of fees, we need to probably broaden it up to include the retirement industry or the retirement savings broadly, including the fees that are eating away the unclaimed benefits that are currently in place.
Okay. Somebody would have to assist us as to what do we say on the funds that are not under FSCA supervision. There can't be a lawlessness in this country. Isn't it what dealing with? The information you gave us is what is on the left, funds under FSCA supervision. Then we'll have to deal with these other ones, because it means we won't get information from FSCA on those who are on the right of the table, if you can see the table here. We are a standing committee on finance of the Republic of South Africa. So no one will be not under supervision, because you don't want to be under FSCA you will be under parliament if you run away from FSCA. So we'll have to deal with that. Sister Alvina, do you have any suggestion as to what do we do? Because they are also causing problems in this regard, and they think they are not under the radar of the FSCA, so they can do as they wish, and that cannot be allowed. National Treasury, over to you.
Okay. The funds that are not with the FSCA, it's what we call public sector funds. So it's the GPF, Telkom, Post Office, and Transnet. So I think the only problem is Post Office, given the challenges that it's facing, but the other public sector funds are not giving us problems. And we are trying to solve that through a measure which you do not like, which is amending the law to put them in. So that is what the coffee bill seeks to do, to ensure that the public sector funds are brought into the purview of the FSCA for supervision and regulation.
Okay. Yeah, no, sorry, members, I have to take much of your lunchtime, but we're dealing with the issue of national interest. We can't be rushing for lunch when there are poor people out there who are going to die this December because they go to an employer and the employer tells them that I've been contributing your money to the Pension Fund Administrator. So you will have to bear with the table for dragging the meeting for such a long time. Because remember, next week, Parliament is rising for the festive season. The next time we come back here, it will be in February. So between now and February, we must have a way of dealing with these issues that are here. I will remain here with the support staff to craft a statement about what we're discussing today. And we'll see how we make follow-up with the Treasury, FSCA, and the PFA on this matter. As you have suggested, that we have to get reports regularly, and then actions will have to be taken. And I think we must start with government. Yes. We must start with municipalities that are defaulting and see what to do. I'll talk to the minister, Honorable Kotongwan, and do something. So people must see us doing something, not workshopping and refer to Honorable Shavisa. Honorable Shavisa refer to mayors, and mayors refer to somebody else. No. We'll have to take actions as soon as possible, because municipalities can't be owing water boards, owing ESCOM. Now they are owing pensioners. I mean, where is the money going to? They are even owing residents. No services in some municipalities. So they're owing everybody. Pensioners, they are owed. ESCOM is owed. Water boards is owed. And so on and so on. So it can't be business as usual, and we keep quiet as Parliament. Thanks very much, honorable members, National Treasury, FSCA, PFA. FSCA, there's a matter here. Can you please deal with it? Under 5, because I'm under pressure. These members are going to participate in debates. Let me allow members to leave, and we agree on how we deal with this matter under 5. There's somebody who has complained, and we'll see, we'll process it and report back to you, honorable members, about FSCA and pension issues. It's going to take much longer, and I don't want to remain here till 2 o'clock. We'll report back to you as to how we'll have processed the matter. Thanks very much. The meeting is adjourned. Can FSCA remain for a few minutes? We deal with item under 5. How do we process it and report back to the committee? And the support team remains.